HR leaders know hiring is getting harder. A new survey from Robert Half reveals companies are hiring for critical roles, making competition for top talent fiercer than ever. So how do you stay ahead? With insights that matter. The Demand for Skilled Talent report from Robert Half dives deep into hiring trends and the impact of AI on critical skills and staffing needs. Get the data that drives smarter hiring. Head to roberthalf.com/demand for skilled talent.
Hello, and welcome to Honest HR. I'm your host, Monique Akanbi. Did you know that the Family Medical Leave Act is one of the top 3 topics we get questions about in our Knowledge Center? Also, according to SHRM's research, 89% of employers agree that there should be more education and training for both employers and employees regarding FMLA rights and responsibilities. So, today, as one way of helping provide more education and training, we'll be answering some of our members' most common questions around FMLA right here on Honest HR. Joining us today are 2 resident FMLA experts here at SHRM, Liz Peterson, Manager of Knowledge Operations, and Sherry Martell, Lead of Total Rewards. Welcome to Honest HR, Liz and Sherry.
Thank you so much.
Thank you.
All righty. So before we get to our members' questions, I have a couple of context setting questions, both for you, Liz and Sherry. So Liz, how would you describe the value our Knowledge Center offers to our members?
Thank you so much, Monique. That's a great question. The Ask an Advisor service is part of our Knowledge Center at SHRM, and it's a member-only exclusive benefit that allows us to provide personalized guidance to our members on their most complex HR challenges. And it provides a way for us to be a peer to other members, just bounce ideas off of each other, or to provide resources and information. And it helps our members navigate workplace issues efficiently. It saves them time, and it helps you mitigate risks for your organization.
Awesome. Well, Liz, I have to tell you, I had the opportunity of visiting a lot of our affiliate conferences or speaking at conferences and speaking about the benefits of being a member of SHRM. And every time I highlight our Knowledge Center and our knowledge advisors, if I had $1 for every time someone came up to me afterwards and said they didn't realize that that was a benefit available to them as a SHRM member, I could probably retire. So thank you for sharing that. Now, Sherry, why would you say FMLA is such a critical topic for HR professionals to stay on top of?
That's a great question. Every HR professional should be up to date on FMLA, its rules, its requirements. It's such a big part of compliance when it comes to being an HR professional. And it's getting more complex every day. And not only do we have many people working remote, which means employees located across states, there are now numerous states that have their own paid family and medical leave laws. And it's important that companies and HR professionals understand what states have those laws and what they entail and how they work in conjunction with or separate from FMLA. So there's always something new to learn. It's always evolving, and it's important that HR professionals take the time to really learn and relearn what's going on in the world of FMLA.
Thank you so much for sharing that, Sherry. I will tell you, I often say I have the unique opportunity to still be involved in HR and my role with SHRM, but not have to practice day-to-day HR. So you're just talking about FMLA and managing the compliance and the various leave laws of either state law, and then you have FMLA. I do not miss it at all, but I echo your comments around it being critical for HR professionals to really stay on top of it and to understand how your state law works with FMLA, which is the Federal Medical Leave Act. So Liz, I'd love for you to share with our audience how you narrowed down your questions around FMLA, or the questions that you all receive at the Knowledge Center around FMLA.
Sure. So once we found out that we were going to do this Honest HR podcast, I looked at all the FMLA questions that we've gotten in the Knowledge Center the last month, And I, of course, use AI because that's the most efficient way for me to do it. So I asked AI to look at all those questions, which is a ton, and help us determine what are the top 5 themes. It ended up that we found out that we had eligibility and coverage was theme number 1. Number 2 was intermittent leave management. 3 was employer obligations and compliance. 4 was job restoration and performance issues. And 5 was special circumstances and complex scenarios. And then I asked AI to come up with, paraphrase actually, 3 questions under each one of those themes. And those are the questions that we're going to use today.
Awesome. So you used artificial intelligence, and we have a phrase at SHRM, AI plus HI, which is your lovely human ingenuity, equals ROI. So I love that you utilize AI to identify or to kind of maybe pull those trends or themes around some of the common questions that we receive in our knowledge center around FMLA. So let's get to our questions. You mentioned, Liz, that the first theme was around eligibility and coverage for FMLA. Sherry, if you can tell us, how do we calculate employee eligibility for FMLA if they're close to meeting that hour requirement, but fall short maybe a few hours or days?
Definitely. It's so important that we're always calculating those hours to make sure that employees have met that annual requirement that they need. If someone's falling short or, close to those hours, it's important that you double check your payroll records. Ensure that all time worked has been accounted for. Make sure that you're including overtime, any compensable hours for travel or training. So make sure your hours are completely accurate. Also, check for the proximity of the eligibility. It's possible that the employee is just 1 or 2 days or a few hours shy. Example, if they work a 40-hour work week normally and they are 10 hours short, they will meet that requirement in just 2 to 3 working days. So be sure that you look at when they're asking for that leave versus what start date they're actually looking to take it. They might qualify by then. It's also possible, depending on the circumstance, that employee might be able to postpone that FMLA leave by a week or 2 if it's, say, a planned surgery or something like that. It's really important to have that open and honest communication with employees all the time about what qualifies as hours and where they stand in those hours so they aren't caught off guard when they're looking to use FMLA leave.
I love that you mentioned checking your payroll records, because I think oftentimes we just automatically assume, right, they work a 40-hour work week, that they worked those 40 hours, but making sure you go back and check your records to ensure that they met those requirements. So thanks for calling that out, Sherry. Now, Liz, there is a requirement for employers to offer FMLA as long as they have employees within a certain mile radius, right? So does an employer with multiple locations need to count employees across all sites to meet that 50 employee threshold within the 75-mile radius?
Okay, now this question's a little complicated because it overlaps 2 different things. One is employer coverage, and then the other is employee eligibility. So I'm first going to talk for those employers that are small, close to 50 employees, and just make sure that they understand that it's 50 employees within 20 work weeks. So 50 employees on your payroll. We're going to talk about temps in a minute, but for 20 work weeks in the current year or in the preceding calendar year. And if that happens, then you are an FMLA covered employer, and you do need to have that poster up, even if nobody in your organization is eligible for FMLA. And let's talk about that multiple location situation. So what you want to do is a 75-mile radius. So you want to look at each person to request FMLA and whatever location they report into, that's where you start that 75-mile radius for what other locations or employees may be in that radius. Keep in mind that remote workers do apply to do count towards whatever location they report into or that directs their work.
So, follow-up question to that. If I am an employer and I have, let's say, 80 employees that work at our home office. We're based in a specific city. I'll just throw a city out there, Charlotte. However, I have employees. I have maybe about 12 employees that works at a client location, let's say in Miami. Would those employees be eligible for FMLA? And this is both either Sherry or Liz. You can answer that.
Yeah,
question.
I can follow up on that one. So the employees at headquarters, yes, there's 50 employees within a 75-mile radius. The employees that are in Miami, unfortunately, if there's not 50 employees within a 75-mile radius or other remote employees that report into that location, they're probably not going to be eligible for FMLA. You would want to check any state law or if they might be eligible for ADA. Sherry, did I miss anything there?
No, that is spot on. I was thinking the same thing. It's a very tricky situation, and you have to be aware of exactly how many employees you have in those locations.
Awesome. Thank you. So, Sherry, can temporary employees or part-time workers qualify for FMLA? And do their hours count towards their eligibility if they're eligible?
Absolutely. If a part-time employee meets the same eligibility criteria as a full-time employee, meaning they can make that 1,250 hours in that year, then they can use those hours towards FMLA eligibility. So it's for everybody as long as they can meet that eligibility criteria.
Okay.
Yeah, and I want to just clarify that that's whether they're through a staffing agency, doesn't matter whether they're on the company's payroll, direct hire, or a staffing agency, the hours still count. It's just a matter of it's a joint employment situation. So they would count towards, if you were temp to perm, you would count those hours and continue to count those towards their seniority for FMLA.
Got it. Okay. Well, if we thought eligibility was complex, my next area is going to be even more complex, and it actually brings back memories, which is the second theme of intermittent leave management. Right? That's the emotion. That's the emotion that evokes when I hear that. So, Liz, can we require employees on intermittent FMLA to provide doctor's note for each absence, or follow specific call-in procedures?
So call-in procedures, yes. If it's unforeseeable time and they need to take time off on the day of, then they need to follow normal call-in procedures. You can certainly let them know what those are as part of your normal process. When it comes to doctor's notes, you have to be careful. And when you ask for those, certainly you can ask for the medical certification upon initial request of FMLA. And then it depends on whether that leave of absence is for a longer period of time or a shorter period of time. Generally, if the health condition will last more than 30 days, you'll want to wait at least that minimum duration to ask for a new certification, for recertification, I should say. Doctor's note is considered recertification. Anytime you ask for documentation, you're asking for a recertification of your initial FMLA request. In all cases, an employer may request recertification every 6 months. There are some exceptions. So the exceptions are, and I'm going to have to look at my notes to make sure I don't miss them, requesting an extension. So any leave beyond the normal initial FMLA request. If the circumstances significantly changed, so such as the duration or frequency of the absence has changed, and then if you received any information that casts doubt on the legitimacy of the FMLA request. So, for example, if the employee regularly misses Monday mornings and Friday afternoons, but doesn't really miss time in the middle of the week, asking for clarification of, is there a reason for this pattern of absence, and get more documentation.
And speaking of leave patterns, right, there's always potential misuse. So, Sherry, how do we handle situations where there's intermittent leave patterns, for example, an absence every Monday and Tuesday? If that suggests maybe potential misuse, or how should we handle, or our audience handle those situations?
Of course, the first thing you want to do is make sure that you are documenting all leaves. So intermittent leave should be documented so you know when it's being taken and you're able to identify those patterns. After that, you definitely want to go and double check that initial doctor's certification. Is the leave consistent with what the doctor approved? If not, then that can raise the red flag. And that can go back to what Liz was saying, where at that time, if it's significantly different than what was initially approved, you can then ask the employee to get recertification to verify that those dates and the leave patterns are correct and that the leave has actually changed. You can be honest with your employee and have those conversations and say, I've noticed this is, a lot more frequently than what your initial leave request was for. I would like you to go ahead and get an updated certificate of leave from your doctor so we can have this new schedule on file.
Liz, can an employer request a predictable schedule from employees using intermittent FMLA to minimize disruptions?
The answer is it depends. It depends on whether it's foreseeable or unforeseeable types of leave. So foreseeable might be scheduled treatment, regular appointments that you have with the doctor to seek treatment. If it's unforeseeable, episodic, maybe they have migraines and they get a migraine periodically, but it's not foreseeable. So you can't really say, well, I don't want you to have a migraine on the day that we have end of month reporting requirements. So that's not something that we can do. So you can't really require that type of a schedule for the unforeseeable, but for the foreseeable, you can certainly request it and ask them to try to get those appointments as best they can in the least disruptive time period.
Now that brings us to our third theme, which is employer obligations and compliance. So Sherry, are employers required to continue health insurance benefits for employees on unpaid FMLA leave? And what happens if those premiums are unpaid?
Absolutely. Employers must continue to pay for the employee's insurance premiums while they're on leave. The employee, however, is still obligated to pay their portion. So they still need to make those payments. If the payment is left unmade, you can cancel their insurance. I recommend giving a little bit of a grace period for an employee, maybe a 30-day grace period, so they have a little bit of time knowing that they are on leave and possibly not being paid to make up those payments. But you can, if no payment is made, cancel their insurance. But keep in mind that you must give that employee 15 days written notice of the intent to cancel their insurance before doing so.
That's very important, making sure that you give them that notice, that 15-day notice, but then also giving that grace period, right? Because if they're requesting FMLA, it is our hope that it is a true medical event that they're dealing with and they need those benefits. Liz, if an employee fails to return their FMLA paperwork within those 15 days, can we deny their leave or apply attendance policies?
So, yes. Generally, an employer can deny or delay FMLA leave if an employee does not return their certification within the 15 days, as long as the certification form was informative enough to let them know of the consequences of not returning it. The FMLA DOL form does include that language, so if that's what you're utilizing or something, you want to make sure you utilize as close to the specific language that the DOL provides to make sure that you provide all that information to the employee as part of the complete and sufficient certification. But an employer can deny or delay it. There is an exception, which is if it's not practical for them to get that certification back to you. So if there's some extenuating circumstances, an employer should consider those. For example, I had a situation where an employee told me they had FMLA. I was ready to send them all the paperwork and I was waiting for the certification form. It never came back. I called them up and was like, why, what's the delay? We're at 15 days now. And they said, I'm so sorry. My doctor, got called out of country for 3 weeks and they're returning next week. So I haven't been able to even get in to see them. I wish they had contacted me sooner to give me that notice, but it was an extenuating circumstance. I didn't feel like it was practical for them to go find a whole new doctor to talk to them to get the doctor's notes. So it was definitely a situation where I wanted to just delay the requirement to return the paperwork and time to allow them time to get the doctor back and have that follow-up appointment so that they could get that paperwork completed. So that was one of those extenuating circumstances. But if there isn't an extenuating circumstance, the employee's just not returning it and they're not following up with you to let you know what's happening, then you can delay or deny the FMLA leave, and it would fall to their company policies. So if their company policy is that they can only have so many absences or they've exceeded their sick leave, whatever the case might be, those policies would be applicable.
So it sounds like communication is key, especially when going through that process. Sherry, can an employer retroactively designate FMLA if the employee has already been out for several weeks?
You can, depending on the situation.
Mhm.
I think this comes up often with FMLA because a lot of times people go on leave for an illness or an injury and they're out for 1 or 2 weeks, and you may not find out about it or realize that they're out for an FMLA qualifying condition until they've already been out for a week or two. And if that is the case and the reason they're out does meet the FMLA qualifications, you can retroactively designate that as FMLA leave. You just want to make sure that whatever you do is not at detriment to the employee's rights. So as long as it's favorable to them and they're on agreement with it, you can do that. Again, documentation and having that open communication with that employee so they understand what's happening is so important. So there's no confusion.
So our fourth theme, which is job restoration and performance issues. Liz, can we move an employee returning from FMLA to a different position if their original role has been eliminated or perhaps filled?
So it depends on whether the different position is an equivalent position. If that's the case, it would have to be equivalent pay, benefits, working conditions, all the things. Location, all those things would have to be considered equivalent to the employee or more beneficial. In those cases, an employer could certainly offer those options. If a position is eliminated, an employee has no greater right to continued employment than if they were not on FMLA. So if that job elimination would have let this person go had they not taken FMLA, or would have said, we don't have your position, but here's another position, then an employer would need to provide that same type of option to this employee. Make sure that there's good documentation to prove that this decision was not made based upon the FMLA, but it was a business decision and there was selection criteria utilized. So documenting all that is very important. When it comes to another role being filled, generally an employer would have to displace the person that came in and filled the role for the individual who's on FMLA, unless again there's an equivalent position available. So generally when somebody's off on FMLA, an employer can temporarily fill a position, but they shouldn't necessarily assume that that position's filled and they would displace the person on FMLA. The person on FMLA has the right to job restoration, to come back to their current position, and that person that filled that position temporarily may be the one that has to move to the other position available.
Got it. So this is where it gets tricky, and I am going to ask you this, Sherry. So how do we handle poor performance issues for employees who may have not been performing satisfactorily before taking FMLA, and then they return? How do we handle that?
This always seems to be a tricky situation. And I think the very first thing to always ask is, was the poor performance documented prior to the person going on FMLA leave? Being on leave is job protection for FMLA. However, it does not reset any performance issues that were already going on prior to leave. So if an employee was already on a performance improvement plan or had some sort of action, it can pick right back up when that employee returns. If there was documentation, you were supposed to have a meeting about disciplinary action and then someone went on leave, and you didn't have a chance to have that, you can still have that when they return. It doesn't reset or start over. That being said, it's anything that is disciplinary action or poor performance needs to be related to prior leave. You can't suddenly bring it up. Oh, before you left, you weren't doing X, Y, and Z, and now let's talk about it now that you returned. that can be construed as, retaliation for FMLA or anything like that you don't want to happen. You want to make sure that you are referring to something that happened prior to leave and that it was previously documented and discussed.
Yes. So the key to that, which every HR professional should know or maybe say it in their sleep, which is document, right?
Definitely document.
Making sure we have proper documentation and addressing those performance issues as they occur and not waiting. So Liz, if an employee returns to work from FMLA, but they're unable to perform the essential functions of their job, or maybe they need an extension beyond the 12-week limit that FMLA provides, how should an employer handle that? Should they pursue termination? Should they pursue other alternatives?
So it depends on the employee situation. If it's their own serious health condition, an employer would need to check if ADA would apply, the American Disability Act. Also, state laws might be applicable. So just looking at what other leave benefits this employee still may be eligible to receive. Also, in addition, any company policies. So if there's a policy allowing for additional personal leave that employee could take, or another medical leave benefit that the company offers for employees beyond FMLA, those things might be eligible for the employee.
Okay, so that takes us to our last theme, which is special circumstances and complex scenarios. Now, we have 6 generations in the workplace today, right? And we hear a lot about the sandwich generation, where you're either caring for kids and parents, or even oftentimes caring for grandchildren as well. So Sherry, can FMLA be used to care for a grandchild under the local parentis provision if the employee is the primary caregiver?
Yes, the short answer is yes. If they are acting as the responsible caregiver for the child, then they absolutely can use FMLA leave. The employer can ask for some sort of documentation, but don't get too in depth, and make sure you're consistent across the board for anyone that you might ask this kind of documentation for. But yes, they can.
Okay, awesome. Well, that clears that up. And so, Liz, how do we handle overlapping FMLA and other types of leave? So maybe short-term disability or even workers' compensation.
So disability and workers' compensation are paid benefits. They're not necessarily approving the leave of absence, but they're paid benefits if a leave of absence is approved. FMLA is the leave approval process. So they often run at the same time. Short-term disability is the paid part of the FMLA leave, as well as if it's workers' comp. FMLA would apply to workers' comp situations. So don't forget that piece of your workers' comp leave is to make sure that they get their certification for FMLA and follow those procedures as well.
Now, this next question is tricky. I've never encountered this. Thank God I didn't. Sherry, if an employee resigns but requests FMLA for a past date, and I guess this has occurred before, we've gotten these questions in our knowledge center, right? Are we obligated to grant their leave request?
Well, I'm happy to say in all my years of doing this, I've never gotten this exact question myself. However, because it is a little tricky. However, there's different scenarios as to why you may or may not have to. So if the FMLA request is valid, then you may still be required to approve this retroactively. For example, if an employee resigns on October 1st and submits the certification on the 5th, showing that they were hospitalized from September 15th to 30th, they're still employed, they've already resigned, they were employed during that time period that they were at, you may need to designate that time as FMLA leave. Does that make sense at all? I hope that clears it up a little bit.
That does, but I hope none of us ever encounter those situations. Again, well, we could sit here, I know I can, and talk about FMLA and all of the special circumstances for hours and hours, but that wraps it up for this week's episode of Honest HR. Sherry and Liz, thank you so much for sharing your deep insights with us. Honest HR is part of SHRM's HR Daily flagship content series. I encourage you to head to SHRM.org/HR Daily to learn more and sign up for our newsletters. You can also catch us on SHRM's social media. Be sure to like, comment, and be a part of the conversation. Thanks for joining, and we'll see you next time.
Hiring is evolving. Is your business? Explore the Demand for Skilled Talent report from Robert Half to see how AI is shaping the future of hiring. Visit roberthalf.com/demand for skilled talent.
SHRM.
This podcast is approved for 0.5 professional development credits, aka PDCs, toward SHRM CP and SHRM SCP recertification. Enter the following PDC activity ID in your SHRM activity portal to log your credit: 26-MYF3J. That's 26-MYF3J. This ID expires on July 1st, 2026.